Hello, and welcome back to the Worcester Senior Center Stay Connected Programming Station Channel 192. My name is Linda Winsteck Moore, and I am the Manager of Senior Services and Education at the Worcester Senior Center. Joining us today is nurse attorney Kathleen Summers from Generations Law Group. With over 25 years of legal experience, Kathleen concentrates her legal practice on crisis planning, Medicaid and long-term care planning, estate planning, and guardianship. She is the go-to expert on helping clients and their families navigate the legal and healthcare worlds when a crisis occurs. She specializes in crisis management and often supports families who are unable to provide frequent oversight of a loved one's care. Kathleen is often sought out by professionals to serve as an advisor to local hospitals and be a member of several boards in the community. Kathleen serves as Vice President of the Massachusetts chapter of the National Academy of Elder Law Attorneys. Today, Attorney Summers will discuss significance of estate planning in the LGBTQ community. Kathleen Summers, RN Esquire from Generations Law Group, will be discussing the importance of estate planning for members of the LGBTQ plus community, including the essential documents every adult should have and the purposes each document serves. Common questions and challenges when creating an estate plan are addressed, such as appointing the right agent, how to make your life wishes known, and the consequences that may arise if no estate plan is in place. So welcome, Attorney Summers. Thank you, Attorney Summers, for that very informative program. And remember, everyone, stay safe, stay hydrated, and stay connected by watching the Worcester Senior Center Stay Connected programming on Channel 192.
Thank you so much, Linda, for that introduction, and thank you to the Worcester Council on Aging and the Worcester Cable Television Access Channel for having me today. Today's topic, we're going to talk about the importance of estate planning in the LGBTQ plus community. And I want to just begin by just talking about estate planning to be for all of us and our belief in its incredible importance in ensuring a couple of things. Number one, to make sure that, of course, wishes after we've died are clearly understood and clearly followed, but also the importance of making sure our wishes are known and followed while we're still alive, but if for some reason we're not able to control things for ourselves. So I'm going to take a moment and just share with you all our presentation for today. So again, I'm Kathleen Summers, and I'm a nurse attorney with Generations Law Group. And we really focus on this area of estate planning for all and trying to ensure that wishes of our clients are understood and followed. So some of the reasons why estate planning is particularly important to those who are part of the LGBTQ plus community is because oftentimes even longtime partners are unmarried. We all know with DOMA that now being allowed and recognized as married couples certainly helps in the estate planning realm. But oftentimes we find that longtime partners are not married. And so making sure that you have taken steps to protect yourselves and to protect each other is important, to make sure access to information is there, to make sure, again, that wishes after you pass are clearly followed and understood. We also find that oftentimes individuals can be estranged from their families. And of course, when someone becomes ill or after the death of an individual, we oftentimes find that estrangement ends up becoming an issue, and family members who had not been involved suddenly insert themselves in one way or another. So it's critical that you have a comprehensive estate plan to make sure that there's clarity about who you want to be involved in decision making. Again, should you be alive but incompetent or incapacitated, and certainly that your wishes after your death are clearly understood and who you want to be in the important decision-making positions and control of things is clearly understood. Oftentimes, individuals in the LGBTQ plus community have created their own family out of friends. Their community now is part of their greater family. And again, making sure that there's clarity in their estate plan and understanding how those members will or who will play important positions within their estate plan and how their estate will eventually be distributed after their passing is critical. So having a comprehensive estate plan and understanding what that means is really important to members of this community. Remember, an estate plan is not just for people who are wealthy. I had a client the other day who said, oh, I don't have enough wealth to have to worry about a trust, let's say, or even to have to put an estate plan together. And that's not true. An estate plan covers more than just how you're going to divide or give up your worldly goods after you pass away. Again, it can talk a lot about how things are handled while you're still alive, but should you become incompetent or incapacitated and unable to make decisions for yourself. So a comprehensive estate plan is really going to touch on all these important areas. So let's talk a little bit about what the components of an estate plan are. There's really 5 main documents that we recommend everybody consider when putting together their estate plan. And I'm going to go through all of those with you. It really is powers of attorney, your healthcare documents, including the healthcare proxy, your living will, your HIPAA authorization and release forms. I'm going to talk about the last will and testament as well, and then I'll talk about trusts and how they play into an estate plan. So let's start with talking about a durable power of attorney. Then these documents, these first few documents that I'm going to talk about, really help to manage things while you're still alive. But if you were to become incompetent, incapacitated, or unable to manage your own affairs for any reason. So a durable power of attorney is a very broad-based document in which you ask somebody to step into your shoes to manage all decision-making for you but healthcare. We really see it as a financial tool in many aspects because it gives authority to the person that you've asked to step into your shoes to access your bank accounts, to pay your bills, to make decisions about your property, about how your investment decisions, about how your money may be invested. They can handle your retirement plans, life insurance policies. So it's a very broad-based document. In some instances, it actually allows somebody to be able to make decisions about where you may live, and what kind of, not your health care itself, because I'm going to talk about healthcare proxy, but what kind of community or environment that you should be living in and what kinds of services that you may need. And so a power of attorney can be very broad-based because we don't know what types of things your attorney in fact, and that's what we call the individual who would be stepping into your shoes, may be facing. And so we give them very broad authority to make a whole slew of decisions on your behalf. One of the reasons we call it a durable power of attorney is because, interesting enough, the law about powers of attorney actually states that it no longer has effect once you become incompetent or incapacitated. But in fact, that is the whole reason we want the power of attorney in place. So we make it durable so that it will continue to be effective even if you become disabled or incapacitated in any way. There are 2 types of powers of attorney to know about. One is considered an immediate power of attorney. That means that it is effective the moment you sign it. And sometimes we'll put these in place for people who are in long-term relationships and they've named their partner as their attorney in fact. Or if you are an individual who may have either young children or younger children who are now adults and want them to be in that position, and you are healthy and capable of managing things, but you do not want to have to manage your bills anymore, you can go ahead and give immediate authority to your attorney-in-fact to start handling things. And what this means is that you don't have to be incapacitated, you don't have to be incompetent. Maybe you just no longer want to take care of your bills. You really want somebody else to manage that aspect of things for you, or you're finding it difficult to handle the finances. You could ask your attorney-in-fact to immediately step forward and start to help you. The other type of power of attorney is called a springing power of attorney. This requires that you are first declared incompetent or incapacitated, and so there must be some documentation by usually either your primary care physician or another healthcare provider who knows you, who says that you are no longer able to manage your own affairs, and they activate the power of attorney. So with the springing power of attorney, there needs to be a reason for your attorney-in-fact to be able to step forward. And they have to have documentation to support that and to support the activation of the document. So it can make it so there's a little bit of a check and balance in place, in the sense that nobody is out acting on your behalf without a good reason. But do remember, with a springing power of attorney, it can also put a little bit of a roadblock in the way of your attorney-in-fact, because now they have to go and actually get documentation in place to be able to show that they have the authority under the document to act. And so it can be a little cumbersome for them, but it really does provide a good check and balance to ensure nobody is acting on your behalf unless there's a valid reason. So that's a power of attorney. It's very broad-based. It gives a tremendous amount of authority to the named attorney-in-fact to be able to act on your behalf. Now, why do we put these kinds of documents in place? It's giving somebody else a tremendous amount of authority to act for you. And the reason why is because if you become incompetent or incapacitated and you can no longer manage your own affairs, if you don't have a power of attorney in place in which you've identified and named who you want to be in that critical position, we now need to turn to a court and get a conservator appointed. Now, a conservatorship is a cumbersome process. It involves a court. It involves oftentimes needing to identify and to be able to provide notification to your heirs. And the people who may be involved in a conservatorship may not be people who you would normally want involved in these kinds of activities regarding your life. And you also no longer have control over who gets appointed as your conservator. And lastly, it's a very expensive procedure or proceeding to go through. And so having to utilize the courts to name a conservator is something you really want to avoid where possible. And putting in place a durable power of attorney ahead of time will allow you to do that. It will also allow you to ensure that who you want to be named as your attorney-in-fact is recognized. And you can also tailor the requirements or the powers under the power of attorney to meet your particular needs, so that there are specific powers that get enumerated for your attorney-in-fact to follow. So that's really powers of attorney and how they work. The next documents that I'm going to talk about are all healthcare related documents. And the first one is a healthcare proxy. And I like to think of the healthcare proxy, it's really a power of attorney for healthcare related decisions. Now, the healthcare proxy law is specific here to Massachusetts, in which we allow you to name a person to step into your shoes to make healthcare decisions for you in the event that you're incompetent or incapacitated. Now, this particular document is actually springing by law, which means that you must be incompetent or incapacitated before it becomes effective. So the document has to be activated. If you are capable of making your own healthcare decisions and you're competent to do so, then your decisions are the ones that are followed. So the healthcare proxy document actually needs to be activated by the healthcare providers before your named agent or your healthcare proxy is able to step forward and make healthcare decisions for you. Now, a couple of things to remember about the healthcare proxy. It is just a document that gives authority to somebody else. So it actually talks about all kinds of different authority that the person is given by you in order to be able to make healthcare decisions on their behalf. It doesn't speak specifically to what your particular wishes may be in a healthcare crisis. So it doesn't talk about wanting extraordinary measures or not wanting extraordinary measures, being kept alive on a ventilator or not, receiving things like feeding tubes or getting something like end of life treatment. It doesn't talk about that. Instead, it gives authority to your proxy to make decisions for you. So one of the things that's really critical is that you make sure you speak with your healthcare proxy at length and that they understand and have a framework for healthcare decisions in the future and that they understand what's important to you. So if it is a position that they end up having to fill because of some kind of crisis in the future, that they understand the framework for healthcare decision making. They understand what's critical to you, what's important to you, what your philosophy is around healthcare. So making sure you have that conversation is absolutely imperative to give your healthcare proxy the framework they need to make the decisions on your behalf. A couple of other things to know about a healthcare proxy. There is the one-page document that you can pull off the internet, and certainly having that in place is better than not having anything in place. But working with a professional to get a little bit more of a robust document can be very helpful because of a couple reasons. Number one, there's a need to really address the issue of the approval of something like antipsychotic medications and their use, should it be appropriate in your care. We want to make sure that the healthcare proxy document actually allows that so that if it's needed, your agent is able to make the decision to utilize those types of medications in the right circumstances. There can be some other reasons, like needing to have something like nursing home care in the future and place you in a facility. Again, having explicit authority to be able to do those things is extremely important for the agent in case those issues come up. One thing to remember about a healthcare proxy, as well as the power of attorney that we talked about and the rest of the documents we're going to talk about other than the specific type of trust, is that these kinds of documents can be revoked by you, changed by you at any time, as long as you're competent to do so. And in the case of a healthcare proxy, it can be revoked by you at any time, even orally if necessary. So something to remember, you continue to have the control as long as you're competent and capable of being able to express it. So remembering to talk with your healthcare proxy is imperative so that they have the framework for decision making. Again, one of the reasons we put a healthcare proxy in place ahead of time is because if you were to lose your competency or capacity and could no longer make healthcare decisions for yourself, and you didn't have a proxy in place naming an agent to step into your shoes, we would need to turn to the courts and have a guardian appointed. Again, a guardianship proceeding is extremely expensive, it's time-consuming, and you don't have control over who ends up being placed in that very important decision-making position for you. And so you could end up with someone who you would not otherwise want to be your agent for healthcare decision-making. Making sure you have this document in place ahead of time is critical. A lot of times people have heard about living wills, and living wills are something that we do use here in Massachusetts. They are more of a statement document. So unlike the proxy, which I just talked about, that just gives authority, living wills can be more specific about what your wishes may be. And oftentimes they talk about things like not wanting extraordinary measures. Now, one thing to remember about a living will is they are not legally binding in Massachusetts. If there's a healthcare crisis, we go to a proxy. We look to find a person to make these types of decisions. But we do suggest putting living wills in place, particularly if you're someone who does not want extraordinary measures, in order to provide some guidance for your proxy so that there is something that helps provide a little bit of guidance to them and structure to them for decision making should they have to. Remember, though, that they will always have the last word. They will be the final decision maker and not this document. But it does provide them with some support, particularly around end-of-life decision making. One of the things that you may want to think about if you are facing end-of-life decision making, if you are or a loved one is at the end stages of a disease process, or even in some cases for individuals who may be of a certain age, is you want to talk to your doctor about putting in place a MOST form. MOST stands for Medical Orders for Life-Sustaining Treatment. And this is a much more specific document that you do with your healthcare provider. It will talk about things like not wanting resuscitation, a do not resuscitate order, a do not hospitalize order possibly, not wanting extraordinary measures. It can even talk about explicit things like not wanting feeding tube placement. And so going through a MOST form is a way of being able to document with your healthcare provider what's important to you around end-of-life decision-making. Now, one of the benefits of the MOST form is I like to think of it like a prescription. It can follow you because it is a medical order from one healthcare setting to another and even to your home. And so if you're in the hospital and you're at end stage in terms of the disease process and you're wanting, let's say, to go home for care, a MOST can be put in place and the medical orders contained in that MOST will then be followed, whether you're at home, whether you're in a hospital setting, a nursing home setting, a rehab setting. Any of those types of settings will recognize the MOST and it will be a valid physician's order. So talk with your doctor about a MOST form, see if it's appropriate for you given your current healthcare situation. And the last healthcare document I want to talk about is the HIPAA authorization and release form. HIPAA is the privacy law that went into play. It was actually created in the late 1990s, but it really went into effect in the 2000s. And it is the privacy law that most of us have come up against. This is when you go to the doctor's office and they ask you, may we leave a message on your answering machine or in your voicemail? Who may we speak with about your healthcare concerns and issues? And so one of the things that we want to do in your HIPAA is certainly give your proxies, your agents under your healthcare proxy document, the ability to be able to talk with your healthcare provider should something happen. But you may want to create a larger group of individuals. Let's say you name one person to be your healthcare agent, but you have several friends or relatives that you also want to ensure can speak with your healthcare provider should something happen to you. This allows them to be able to communicate. It gets rid of that game of telephone that we oftentimes have in which information can get lost or distorted, and make sure that everybody's on the same page. But the people named in your HIPAA document are not decision makers. It's only allowing them access to information. So that's really the healthcare related portion of things. Putting in place a healthcare agent under your healthcare proxy, putting in place a living will if it does reflect appropriately your end-of-life decision-making, talking with your doctor about a MOLST if it is something that is appropriate given your particular condition, and then putting in place your HIPAA authorization and release form. Now I want to switch gears and talk about what happens after you've passed away. So all of the documents I talked about previous to this help to manage things while you're still alive, but name people to step into your shoes should you become particularly incompetent or incapacitated at some point. Now I'm going to really talk about what happens after you've passed away. And oftentimes people, are very aware of a last will and testament. And think about this as a document that provides us with an instruction sheet as to what to do with your asset holdings after you've died. And when you talk about asset holdings, we're talking about things that you own individually. So usually if you've owned something jointly with someone else, as long as there's a right of survivorship to that ownership, it will pass to that individual or individuals without having to do anything. The same thing with assets in which you may name beneficiaries, like your retirement assets, your 401ks, your IRAs. These types of assets allow you to name beneficiaries, and those beneficiaries will receive that asset outside of anything I'm now going to talk about. So I'm only focused on assets that you own individually when you pass away, or any interest in an asset that you own individually when you pass away. Remember, your last will and testament is only effective upon your death, and it provides us with a couple things. It will detail for us how you want assets to be divided, who you want to have as your beneficiaries. Either they can be as simple as you want, you just want it to go to a couple of different people or potentially charities, or they can be very complex. They can talk about giving them assets to individuals, possibly even keeping those assets ongoing in some type of a trust situation for those beneficiaries within your will. And so wills can be, again, as simplified as we want them to be or as complicated. The other thing that wills will do is that they will talk about who will be responsible for managing your estate upon your death. We name this person the personal representative. Used to be called an executor, but it's the same thing. This is the person who's going to be responsible for administrating your estate after your passing. So they're going to be responsible for gathering your assets, paying any legitimate bills that may need to be paid, and then making the distributions based on your instructions within the document. Now, another potential role within a last will and testament, if you have minor children, would be the naming of a guardian. And this again would be an individual who you have asked to take care of your minor children until they hit the age of 18. Once they reach that age, then they no longer will be under guardianship. One thing to remember about wills is that they require probate. And so when someone dies, if they own assets in their own name, whether they have a will or not, and when they don't have a will, we call it an intestate situation. And when they have a will, we call it a testate situation. But either way, if there are assets in that individual's name alone, we need to know what to do with them. And so we need to go to a probate court. If there is no will, then what happens is the probate court, the laws of the Commonwealth of Massachusetts, will dictate who is going to get the estate, how it's going to be divided. And the court will appoint someone to be the administrator of the estate. And you will have no control over who that person is. They end up being court appointed. Having a will, again, allows you to be able to identify who you want to manage things after your death and how you want things to be distributed. But the court still needs to recognize your last will and testament as being your last will and testament, and it needs to give authority to the person that you've named as your personal representative to be able to step forward and do what you've asked them to do within the will. So probate is a little bit of a time-consuming process. It does get a little bit of a bad rap out there because it does take time. First of all, it takes about 9 to 12 weeks, and that really was in the pre-COVID arena. Now that we've been dealing as well with this pandemic, it has increased these time frames. But it takes about that much time just to get your personal representative the authority that they need to act on behalf of the estate. And so during that time, there can be a period in which nobody is able to access assets and they're not able to function on behalf of the estate. Also, an estate must stay open for at least 1 year from the date of death in order to be able to let creditors come back at it. So MasterCard, Visa, etc., they say, hey, you owe us something. They have up to 1 year to make a claim against the estate. And then typically it takes about 3 to 6 months after that in order to close down the estate. So the typical personal representative has about 15, 18 months that they're dealing with the estate, trying to make sure that what you have asked them to do gets accomplished. So that's really an overview of probate. It does involve the courts, and it also, because it involves the courts, does give an opening for people to argue about your estate and what your last will and testament may say. Your heirs at law are notified of the proceeding, and they have an opportunity to be able to come in if they choose and argue about the validity of the will. So last wills and testaments can be a great way, absolutely imperative to have something in place about how to divide and to be able to distribute your assets after death, but it may not be the best way given your particular circumstances. So I'm going to talk about an alternative to last will and testaments. And those are really revocable or revocable trusts. A lot of people have heard about these. These are trusts that, couple of things. Number one, during your lifetime, you are the one who creates the trust. You are the trustee, so you control the trust, and you are the beneficiary of the trust. And so during your lifetime, you're able to have full control over the trust. You're able to change its terms at any time you want. Use the assets in the trust in any way that you choose, sell them, put them in, take them out, buy new things, do whatever you want without owing anyone an explanation. A revocable trust will run under your Social Security number during your lifetime, so it doesn't change your tax reporting. And it's revocable, meaning that you can change its terms at any time, amend it to reflect whatever might be going on in your life at that point, or revoke it completely. But here's a couple of reasons why people put revocable trusts in place. Number one, they avoid probate. So what happens is we create a trust. Again, you maintain full control and benefit of that trust, and we put assets into the trust. So we take, if you own a home, any other property, we put that in the trust. Bank accounts, savings accounts, checking accounts, investment accounts, put those into the trust. There are some assets that can't go into the trust. So something like a retirement asset cannot go into the trust, but other things can and should. Again, during your lifetime, you retain full control over those assets. But when you pass away, you name a successor trustee who will be able to immediately step forward and be able to do whatever it is you have instructed them to do within the trust with the assets. So as long as we've taken and put all of your assets into the trust during your lifetime, then upon your death, we don't need to deal with probate. And your successor trustee is immediately able to access the assets, pay the bills, do whatever it is that you've asked them to do. So you are maintaining control over who you've asked to be in that important position and how you want things to be managed and distributed after your death. There also can be a really important tax advantage to married couples who use revocable trusts. And really what that is Massachusetts has a death or estate tax that gets applied after an individual dies if they have an estate of $1 million or more. And when we look at the value of someone's estate, what we're looking at is what they own individually, half of what they own with someone else, all of their retirement plans, all of their life insurance policy values, all get added together to determine whether there's a taxable estate. When we have a married couple, we can write a revocable trust in such a way that we're able to avoid the tax when the first of the couple dies and reduce the estate tax exposure when the second of the couple dies. And so it may be a way of really helping to reduce what otherwise could be a fairly hefty tax bill when the second of the couple passes away. So a few things to remember about revocable trusts is that you retain the control of them while you're alive. They're for your benefit. You can amend them, change them in any way you want. They will avoid the probate process as long as they are properly funded during your life. And they may help to reduce the estate tax exposure when we have a married couple when the second passes away. One thing, though, to remember, because nothing comes without some downside, one of the downsides, really the main downside of a revocable trust, is that it provides no protection for you. So because you have full control of the assets, because you can do whatever you want with them, assets within a revocable trust are as if they're yours. And so if you're sued, if you need something like Mass Health, Medicaid help in the future for nursing home care, any assets within that trust are considered yours and would be exposed to your life. And so just the fact that you have them in a trust doesn't protect them if it's a revocable trust. So now I want to just go on and talk a little bit about protection trusts and how those work. And these are called irrevocable or irrevocable trusts. And the purpose of these types of trusts is to protect whatever type of asset we're putting into it. So like revocable trusts, irrevocable trusts also avoid probate. The assets within that type of trust do not need to be subject to probate. They can be written in ways to help reduce estate tax exposure, depending again on what your goals are. And oftentimes people use these types of trusts to protect an asset or assets from their future needs, like nursing home care. So for instance, you own a home, so a second home down on the Cape, let's say, and it's imperative to you that you protect the value of that home for your named beneficiaries, so whoever you have decided you want to benefit from that trust. You can set up an irrevocable trust, place the property into that trust. You would name the trustee. You would not be the trustee, so you could no longer control things, but you would name another trusted individual to be in that position. And you would outline how you want that asset to be handled and distributed, both during your life and after your death. A couple things, though, to remember with a properly created or drafted trust is that to make the irrevocable trust work, you cannot benefit from it. Now, there are some ways that we might be able to get you income from the trust, but you cannot access the principal value again for your use. And so that's something you have to be aware of, is that you are taking an asset that would otherwise be available to you, and you are putting it in a place where you're no longer going to be able to access it for your future needs. Now, they're a little bit more complicated than that. There are some things that we can do in irrevocable trusts to make sure that your trustee can access those assets. and possibly distribute to themselves or to other trusted beneficiaries that you have named, with the intent that if you needed the asset, they would be willing to gift it back to you. But we cannot make that happen. We cannot force a trustee to make those decisions, and we cannot force the beneficiaries to provide for you. So when you use an irrevocable trust, you really need to be sure that you are comfortable in placing that asset or assets out of your future reach and taking it away from your future needs. And thus we're protecting it should you need something like nursing home care in the future. So remember, with irrevocable trusts, the purpose is to set up a vehicle that allows for the protection of an asset from your life and your needs, but it does take that asset out of your use and control. And there are some rules around it. In particular, if you're using it for nursing home type protection, Medicaid eligibility, you have to set up and fund these types of trusts at least 5 years before you may ever need mass health or nursing home level care. So I hope that was helpful in terms of understanding basics of estate planning and why putting in these important documentations is really something we encourage you to do in order to make sure that you continue to maintain control should you be in a position in which you are incompetent or incapacitated, that you've named the people who are important to you to be your beneficiaries and to be your decision makers should something happen, and that you're able to clearly outline how you want assets to be distributed after your death. Wishing you well. Thank you.